Okay, since I got the little button that says it's recording, I think we can start. So to begin, we'll do a formal roll call to establish quorum. So I'm just going to go in order on my screen here. So Josh Esme.
Here.
Dewan Tatum.
Here.
And I want Vice Chair Gina Evans.
Present.
And Tashonda Williamson. Ms. Williamson, can you hear us? Well, I see she's present, but maybe having some technology issues. And Mr. Vogel, if I remember from last time, I believe Mr. Kammer is more of an observer. He's not formally on the committee. Is that correct?
Yes, as far as I'm aware. Professor Kammer, is that true, or have you gotten an email from Chair Geffen in the past hour?
I have not gotten an email. I requested appointment to the data subcommittee, but I'm planning to attend other ones just to stay as educated as I can. So I'm here as a guest today.
Okay, perfect. So I do believe, Mr. Vogel, is that sufficient for a quorum?
Yes, Chair Dawson. Based on the responses and that's 4 members present, and informally Ms. Williamson's present, so a quorum is present.
All right. So the next piece is that I do want to make a note, and I was double checking it, that the copy of our the December 21st meeting minutes have been posted to the task force website. I'm not sure if anybody got a chance to look at those. I was actually pulling them up as I was also attempting to log in. So I'm not sure if anybody got a chance to look at those, and if there are any corrections or any sort of issues with those that anybody saw. No.
No additions.
All right. Perfect. So then with that, oh, I'm pulling up the wrong one. I'm having technology problems this morning. So then with that, with no objections, I can declare the meetings are approved as they have been distributed. So then the next piece, just kind of to keep moving through here this morning, is, as we had discussed last time, Mr. Vogel was going to do some research and provide us with some sort of an informal presentation. I know, Mr. Vogel, we've had the holidays, and so I understand things have been quite busy, but just if you could then, as we discussed, having an informal presentation on your comparative research with the other 49 state statutes, and then of course, we'll ask any questions afterward. And I think, as you noted, you're able to do a compilation of a list of equivalent state statutes to our 245C, and then any potential progress in identifying states with permanent disqualifications, and in identifying states which provide equivalents to set-asides and variances. Does that sound correct?
Apologies, I was muted. Yes, Madam Chair.
Okay.
And so, yeah, I can get started.
I can turn the floor over to you.
All right, thank you, Madam Chair and members. So as you noted, it has been the holiday season and rather busy. So the high level conclusion of this talk is research is ongoing, more is needed. That being said, I have, while working with the legislative library staff, compiled a list of statutes equivalent to 245C, with an asterisk that it's sometimes like comparing apples and oranges to compare other state statutes to Minnesota statutes. Pretty commonly, a lot of states may have one statute for nursing home and other staff who might work with vulnerable adults, and a separate statute to work with children, foster children, that sort of thing. So the list I in the library have worked up is a list in progress, but it's at least been a useful jumping off point. And in identifying permanency, in the interest of getting a complete answer, or at least the beginnings of a complete answer by today, I've focused mostly on the statutes that we've identified that deal with nursing home employees, working in the medical field, otherwise working with vulnerable adults, rather than statutes pertaining to fostering or that sort of thing. So that's a major asterisk on what I'm about to report that I'll have more worked up on later. So moving on from that then, I have been able to identify 43 states that appear, including Minnesota, that appear to have some sort of permanency in their statute. Of the other 7 states, most of those are ambiguous. Nebraska, in particular, appears to give discretion to employers. It requires a background study, but doesn't have anything equivalent to our DHS determination. So there's a couple of odd states out, but it appears that having some sort of permanently disqualifying list of crimes, or I'd say crimes or conduct, but crimes. The majority of these states appear to specify a criminal conviction. It seems to be pretty common for states to specify a permanent list of disqualifying crimes. Of these states, I should note 4 of them I was unable in the time I had to determine if they have a reconsideration, set aside process, whatever you'd want to call it. 6 states appear to have a reconsideration process that should that at least statutorily permits reconsideration for all of the permanent crimes, with the exception of federally mandated permanent disqualifications. Those states are Alaska, Arizona, Oklahoma, Wisconsin, West Virginia, and New York. Sorry, that's 5. No, that's 6 states. I'm sorry. 22 states appear to have a list of permanently disqualifying crimes with either no possibility of appeal mentioned or no possibility of appeal explicitly or appeal explicitly disallowed for at least for those crimes. I'm including Minnesota in that list because the 245C 24, as I recall, bars on the permanent disqualifications under 245C 15 are all of the permanent disqualifications. So Minnesota is actually fairly explicit in that sort of bar to reconsideration. A number of states simply list disqualifying crimes without necessarily a time period attached, which I interpret as permanent disqualification, and then don't provide for a reconsideration process on non-factual bases. There's of course reconsideration disputing fact, but I'm ignoring that for these purposes. 11 states, meanwhile, have permanently listed crimes, either explicitly permanently or simply, disqualifying crimes without a time period specified, but do appear to give a reconsideration process for some of them. But those states do tend to have crimes that there's a bar against reconsideration. So, for example, California has a list of permanently disqualifying crimes. Crimes is accurate. It's a conviction that's required. There is a reconsideration process, but certain crimes are exempted from that process, basically having to do with sexual assault, crimes of that nature. In terms of other exemplars, I just pulled up. Well, I should now transition to saying that I haven't done a deep dive into any of these states as of yet, since I was trying to do a surface level search for permanency. So that would be the next step, and one of the 2 next steps in my further research to compare the specific crimes and conduct that these states do regard as permanent disqualifications or bars, as well as looking into the children issue, fostering. But I did look at some exemplar states. So California would be an example of one of these states that has some permanent disqualifications and some possibility of appealing them. Pennsylvania would be an example of a state that that doesn't have any possibility of appealing a permanent disqualification. Although, as an asterisk, there was a state court case that the state didn't appeal that found that unconstitutional under their constitution. So, and then Arizona, meanwhile, struck me as an interesting example of a state that, near as I can tell, gives their relevant department, executive branch department, complete discretion to find a good cause exemption to the statutory requirements or exception, excuse me. So yeah, just as that's just a preview of the sort of analysis I'll be doing going forward. But just to sum up what my findings so far, anyway, it does appear that permanency is a pretty common practice among the states, both permanent disqualifications and permanent bars, at least for some crimes. Thank you, and I'll take questions.
And if I could just hop in first, one thing, you said it kind of right at the very beginning, but that I think you said a majority of the states actually specify it has to be a criminal conviction. So are you saying the majority of the states don't have the preponderance of the evidence piece that I know has been a big issue for some of us?
Yes, Madam Chair, and I should note I haven't done a systematic look at that yet. That's a project I'm doing on the side of this project for the data subcommittee, and of course I'll keep you apprised when I have that systematically done. But so far it appears, the majority, I want to say the vast majority of the statutes I looked at explicitly say conviction.
And I don't know about everybody else, but I know that to me is very interesting and I think has been a pretty important topic for a lot of us. So I think that that's definitely information, and that's for sure. I believe we had all decided one of the pieces, did we, that we also wanted to look at. So,
Madam
yeah,
Chair.
that's helpful.
Sorry, I should actually correct myself. Explicitly list conviction or as a general rule, being on one of the various registries, the sex offender registry, that sort of thing, which I don't know if that's a quasi-judicial determination, but I don't know what precise evidentiary determination that is.
Hey, can you explain that in detail a little bit, like with the William, with the sexual assault, murder, probably whatever comes after that? Like, what is, so the other ones you should be eligible? Are you saying, like any other crimes in the other states?
Well, so Mr. Tatum, it appears it depends on the state, but for example, with Arizona, I should also say I am not a lawyer. I'm definitely not a lawyer in Arizona. This is not legal advice, but it appears in Arizona that the relevant agency there is given the discretion by the statute to give a good cause exception, period. So whatever the crime, in theory, if I'm reading the statute right, they should be, they could grant you an exception. Now, that being said, I have no idea if they actually do, but that's very different, for example, than DHS in Minnesota being.
So kind of like case by case basis, sounds like maybe?
It appears, so I don't actually know how the practice works in any of these states. You know, for all I know, there's absolutely no way that the Arizona department would give you an exemption for certain crimes. I just have no way of knowing. It's really a question of where is discretion written into the law, right? So, for example, under 245C here in Minnesota, the Department of Human Services doesn't have the discretion to set aside any of the permanently disqualifying crimes if they find that someone's committed them, right? Whereas if I'm reading this Arizona statute correctly, their equivalent to DHS would have that discretion. Whether they choose to exercise that or not, though, is entirely, a matter of their administrative practice. Does that answer your question, Mr. Tatum?
Definitely. Yeah, and one more. I was wondering, like, the states, you said that was that 6 states that was the that were upholding this?
Sorry, upholding what?
The like the
that give this sort of discretion.
Yeah.
Okay. Yeah. So 6 states explicitly do have permanent bars, but appear to me to likely do that, and several other states appear to grant even wider discretion to their executive department. Washington, for example, if I'm reading their statute correctly, appears to simply give a determination of what crime constitutes an unacceptable danger to their department, and therefore I would assume that that department would, not be prohibited from considering somebody who'd committed whatever crime.
Okay. Yeah, no, that's just really important to me. That I like that piece that you mentioned, that they seem more open-minded, being able to, because they have to be doing case by case if they're not just barring, yeah, and with others that's been barred, but yeah, that's it. Sorry.
Oh, no, definitely. That's a great question, Mr. Tatum, and I hope I answered it.
Yeah, thanks. Yep.
I have one, if I may, Will, or Madam Chair. So it sounded like, if I got the number right, there were 22 states that had some form of either explicit permanent disqualification or undefined disqualification. Was that the right number?
So no, actually that's my further breakdown. It seems to me that there are 43 states.
And then
Yeah.
22 have
And 22
the
have
bar
have a bar
or something like the bar. Okay.
Something like the bar. Yeah. And a further 11 have something like the bar for at least some crimes, albeit not all of them on their permanent list.
Okay. And there was one state that you had found some case law. Are you going to have, as you continue this, are you going to have the capacity to, I think it might be likely that that multiple states will have case law, especially for the ones that you're assuming are a permanent disqualification because it's not defined. That seems like that could be something that lots of states might think is a due process violation.
Yeah,
so I just wanted to sort of flag that as something to watch out for.
Yeah, and I'd imagine case law will be a very helpful guide, especially in those cases where I'm assuming what the statute says rather than the statute explicitly saying something. Whether I incorporate a systematic search for case law into my further research, I think is a question of prioritization, though, given my relatively limited research time between this subcommittee and the data subcommittee and administration. So I can absolutely keep an eye out for case law and highlight it where I find it, but just let me know if you'd like me to prioritize systematically trying to find relevant case law.
I would say, especially for states that it appears that their statute offers no remedy, so has something like our bar.
Mm-hmm.
I would want, before we put a number in our report that sort of reports back how many other states have that similar bar, I would want to know how many of them have had their Court of Appeals uphold the statute.
Makes sense.
Well, and I think just kind of as you were talking, it seems like some of this evidence or some of what you were finding, the statistics and the other states, some of it seems to, I think, sort of support at least some of the concerns we've noted. For example, the preponderance of the evidence standard, as well as whether there really should be a permanent bar and if there are other options to look at it. And then even along those lines, last time we were talking about that administrative accountability and which I think DHS is going to come talk to us next time about, if I remember correctly. So I think that'll be very interesting. But some of this all sort of seems to fit under those.
That makes sense, Madam Chair. Just to give you an update on the DHS thing, actually, this is the perfect time to do that. I've not actually heard back from them giving me a definitive answer for the next meeting. I did send in another inquiry today. They've, as you might expect, had a lot of staff off for the holidays, so I would guess we'll get an answer soon, but I can't really speak for DHS, so apologies.
No, I totally understand. And Mr. Tatum, I see you have your hand raised.
Yeah, like the reason, like the information we're talking about right now is very important to me because of I'm trying to figure out what changed. Like why did it get tougher? Because for instance, like myself, being being approved of a set aside and then being changed, come back a few years later, and now I am not, I'm not approved anymore. And,
I think we might know the answer to that, or at least have a pretty good guess.
Please.
There was a statutory change in, I want to say like the 2010s or something like that, where the legislature came in and added that bar to a set aside for a permanent disqualification. So for a long time, even if you had a permanent disqualification, DHS had the ability to look at your case individually and decide whether or not it was safe for you to work in whatever field you were going to work in, despite that disqualification. And
Yeah, to give you some more,
like anything else. But the legislature actually took that away from them, I don't know, like a decade ago. I don't know if that fits with your timeline.
Couldn't have happened. That the time frame is out. You know,
Okay.
I don't know if there was a mistake that they gave. If they gave me a set aside the first time, was it a mistake? So, you know, everybody's playing like they don't know nothing now. You know, so
I feel like what actually happened, Dewan, is the timing on during the time that you did your internship.
Get my set aside in 2013.
Yep.
They
were taking so long to do set asides that I feel like you got through with your internship before your set aside even got done. And
no,
so
I couldn't even do my internship. I couldn't even do it because of when I finished college, and at the end I had to do, you know, practicum prep and then internship, and I had to take another one because I had been out for 2 years.
Got it.
Yeah. And my crime, and, you know, just, you know, we're all in it together, let you know, it's attempted aggravated robbery. When I was 19, I'm 46 now. So there has not been the same pattern of behavior all the way to then. And, you know, so that's what I'm wondering, like, you know, at first I'm like, they're not going to approve me. But then the school approved me. I was surprised because you have to take the set aside before you can even take the course of addiction counseling. So, and then come back in 16. Yeah. And I took one in 17. Then they said I'm disqualified permanently. At first it was, you know, I hired a lawyer, attorney, did all the paperwork, got all that done, and sent it in, and they got back with me whenever they wanted to. It came back disqualification, you know, like permanent. And then before it was like everything was fine. They changed the dates. They changed the not the dates, but they changed the time limits on like what's, because an attempt, it had to be attempt ag robbery. It had to be acceptable. It was 15 years before, and I was way past that.
Mm-hmm.
Yeah, and so I don't know what happened now.
And so they moved that from a 15-year to the permanent.
To the permanent. That's what they did. Yeah.
Mm. Well, and I think that is some of what, if I remember correctly, the other subcommittee, the actual disqualification one, I think, and Mr. Esme, I think you're on that one too, if you can clarify, but I think that subcommittee is also taking a look at what specific crimes qualify, for example, for a permanent or a 15-year. And so that's a very interesting question, I think, for that subcommittee. Am I right, Mr. Esme?
Actually, I'm not on that committee, but I do think that is in there.
I'm on it and I don't remember. I wasn't able to make the last meeting, so I wasn't sure.
I also wasn't able to make it, and it is, though. You're talking about the disqualification subcommittee?
Yeah.
Yep, that is one of the things that they're going to look at, is the permanent list specifically.
But I do think, you know, I think to you, Mr. Tatum, for sure, this subcommittee important to definitely look at is we're looking at not so much the specific crime, but of course, what the permanent bar itself, and if there should be any sort of relief for someone who does have a permanent bar. So I definitely see that and changes that can be done with that. So I definitely think that makes sense. And thank you for sharing.
Yeah, my just want to add my lawyer was going on, well, you can sue this and sue that, and, you know, want to do all this. And I'm like, nah, just hold on for a minute, you know, just hold on. Just been, you know, because I know something's good is going to happen behind it. You know, met Gina Evans, you know, God is good, you know, and just kept pushing forward, though. You know, I work for Ramsey County Treatment Courts. Things are going well. I'm a trainer. So, yeah, I'm really not, but I got to get my paperwork. You know, I'm like, the man does the work, you should get the money, you know, you get paid. The man does the work, you know? And I'm like, yeah, that just does not seem right at all. But I'm being calm and patient with it, though. So, you know.
Definitely. So we've kind of actually moved on to our fourth topic already. Thank you, Mr. Vogel, for the presentation, of course. But definitely want to circle back. And like I said, we've kind of already moved on to discussion of any sort of topics for this remedies subcommittee. And I think some of what we want to make sure we focus on, just to stay organized and make sure that we are actually getting the work done that we want to get done, so that we can be prepared just as we keep moving forward. And so I know maybe if it makes sense to sort of, last time I know we were kind of throwing out a bunch of ideas, and people can tell me if they disagree, but I definitely think, some of what you presented on today, Mr. Vogel, seems to, I think, sort of help us hone in a little bit more, potentially on the specific areas that we may want to focus on. If people, I don't know how people feel about that or what they think, just as we were talking about the preponderance of the evidence and the permanent bar itself versus at least some sort of a remedy. I know we had talked about expungements the last time, but I think if I'm remembering correctly, we may want to hear some from DHS before going too far into that. I don't know if anybody else has any different recollection from that.
Yeah, I remember talking about that. On the expungement thing, I think there is one relatively small technical fix that I think we should end up recommending that just resolves an inconsistency in the statutes. But that doesn't really do much other than just fix something that, from time to time ends up being a problem. I think the bigger question for me on expungements is I would like to hear more from DHS about how they make a determination about which expungements they're going to object to or not, and sort of how that discretion is used. And I think that is also what I'm interested in learning more about how they exercise their discretion in making decisions throughout the reconsideration process too. So I kind of think those two issues are kind of related, and are, my sort of interest in learning more about, like, behind the scenes, how are they making decisions on these cases.
Mm-hmm. And I think that's kind of a big overarching, is whether it's the expungement process or the disqualification process, how are they making these decisions? What are they doing? How does it really work internally? I feel like that's kind of the big overarching umbrella that, of course, and I totally understand, we haven't gotten a confirmation for next time, but I think that will be extremely helpful, especially as we're considering, what we want to recommend and what changes we think should be made. So, but yeah, I don't know, Mr. Esme, did you have more to add?
Just related to that, I'd also like to hear from them how much they perceive change in executive branch administrations can play on that. Like, is this something where they might be doing it one way now, but that's really different than 10 years ago and could be really different again after the next election? And I guess related to that, how much the general employment environment relates to that. I mean, it's all over the news what a huge shortage there is in healthcare. Does that put pressure on them to change how they apply the reconsideration process?
Mm-hmm. I think that's a good question. And I think that's part of, if anything, where this whole task force even came from. I think that's been a big deal too. So yeah, no,
which is great, but I would argue that no matter sort of what the employment environment is, any individual applicant should expect some consistency.
Correct. I would agree. The hope would be that the statute applies the same regardless of who is in office and what is going on socially and economically and politically. That's the goal.
Yep.
For sure. So no, I think that makes sense. What other, I'm not a big fan of just keeping everybody on a Zoom just to have us all here for time purposes. So I think, of course, next time, I think, and Mr. Vogel, if if there's a way that you can kind of continue your research, and if for some reason we cannot hear from DHS next time, do you think it'd be possible to get kind of some more of these where you were going to do a little bit more of an in-depth? So maybe we can still use some of that time next time if DHS is not available?
Absolutely, Madam Chair.
Okay, and then of course, if DHS is available, maybe we can plan for the next meeting that it could be DHS as well as you, and try to get, because I do think having all of that information would be really helpful. And then, I think that at least thinking would be just helpful for us to actually move forward with this process. So I think that unless anybody has any real different thoughts on that, I think that would be a good use of next time if we can have DHS and you, of course. So then just kind of circling back, based on what we heard today, does anybody else have any other kind of ideas or thoughts on topics that we want to make sure we're discussing, or anything else that we want to hear from Mr. Vogel next time as far as research? I know we had asked some questions and asked him to look a little bit more, but anybody else have any other ideas or thoughts?
Yeah, one other sort of broad topic that I think we talked about looking at is what we can do to streamline the decision-making process so that people can get a timely answer that doesn't interfere with the employer's ability to accept their application. Mm-hmm. And then I guess sort of related to that is who's allowed to work during the reconsideration process and who isn't. And is there anything we should be thinking about there in order to broaden that net, so more people can work while they're awaiting their approval?
I definitely think that makes sense. So kind of what I've heard, and I'm trying to, when we originally had the subcommittee on subcommittees meeting, we tried to sort of think about it in terms of buckets. So to me, kind of the major buckets I'm hearing are, of course, the preponderance of the evidence, the conviction standard versus having the preponderance of the evidence, permanent disqualification, whether it's necessary, if there are other options for remedies, and then just the decision-making process in general, the timeliness of the decision. Like you just said, who's allowed to work. And then, of course, what we still need to hear back on are the expungements and whether that sort of fits in. But is there any sort of other major bucket that people don't feel like we've addressed?
I don't know if I'd call it another completely separate bucket, but again, just to keep things on people's mind, there's the whole variance issue too. Yeah. But maybe that just sort of fits within the, the agency decision-making process. Yeah.
Yeah, I was thinking more like on the, like with the background study check thing of, even we know that people with sex crimes, they're not going to get a set aside, they're not going to get, but at the same time, I think it should be a little bit more personable though, regardless if you know these people, you're not going to get approved. But it still should be more personable, I think, like people, and actually put a face to them, and actually a better steps to that instead of waiting in the mail, not knowing when you're finna get this and that, where this is coming from, and being disqualified by somebody I don't even know who disqualified you. And that's just, I don't think that's right. Now it's just some thoughts. That's all.
So DeJuan, are you thinking that like having some ability to ask for like an in-person, like, opportunity to make your case, that kind of thing?
Yeah, I think that's really important, because think about what the senator in our first meeting said. He was like, he brought up like, man, yeah, we don't realize the ripple effect of this, of these individuals and what we're going through. And if you can be able to touch these people and they actually can see what these individuals are going through, and then they actually can have empathy for themselves, for others.
Well,
Yeah.
I can definitely appreciate what you're saying. And of course, many of my clients, something may look one way on paper and you actually sit and talk to somebody and it's completely different. Or even you just look at what somebody's charged with and you dig a little bit deeper into the facts and go, well, yeah, maybe it meets the statute, but there's
Yeah,
more.
like with me, I was homeless. When this happened, I was homeless. 17, 18, 19 years old, I was homeless on the streets, not an address, gang member out here. Where am I going? Surviving, so I don't even remember what happened. Well, basically, I know I ain't hurt nobody, so yeah, public defender gave me, oh, you can get out of jail today. Oh, okay. Got out of jail. And now here we are.
Yeah, another advantage of allowing some, in-person meeting is that not everybody communicates real well in writing.
Mhm.
And it's one thing when you are lucky enough to have a lawyer like help you through it, but most people don't.
Right.
And it's
And I see Ms. Williamson, I see you have your hand raised, so I'm not ignoring you. So please go ahead.
No, thank you so much, Chair, and hello, everyone. My apologies that I wasn't at the first Remedies meeting, and I came in here a little bit late. So I just wanted to just make mention, I'm sure that the full list that we were going to address or start has been provided. I have not seen it as of yet. I just wanted to make sure that we are giving attention to the accountability measure in regards to the department, as well as even legal remedy, being able to give like clear grievance steps, clear steps in regards to complaints, timeframes that can be, or expectations that can, in regards to those measures, in addition to doing due diligence to make sure that persons who would not qualify or do not have the financial means that they can still be afforded or resourced legal remedy for those who are considered indigent.
And thank you. And I do want to just let you know, we did talk about the accountability piece last time. And that is one piece that we were hoping to hear more directly from DHS on to get more information to help then guide our thoughts and our discussions going forward. So we are absolutely not ignoring it. And we definitely did discuss it. And that is one piece that we're just trying to get more information on.
Thank you so much, Chair.
Yeah.
And Madam, oh, sorry.
That's okay.
Madam Chair, correct me if I'm wrong, Ms. Williamson, but I think the list she's referring to is the list of data requests that the data subcommittee, which she's chairing, has made of DHS. And you can find a copy of that list on the task force website under the subcommittees tab. I can also provide a copy if you'd like, but that's where you can find it.
And Vice Chair Evans, I do see your hand is raised.
Yep. So I put it in the chat as well, but I was doing some sniffing around. The Council of State Governments has this fair chance licensing project that they're working on that has a ton of data. And I don't know if you ran across that, Will, while you were doing your research. I'm working right now on another project with the Council of State Governments about the justice reinvestment stuff. And so I don't know if that fits with us with Remedies or it fits with the data group, but I bet we could get them to come in and do a presentation about anything that they've come across. I think with the challenge, I'm going to use that word, that we're having getting DHS to give us data, that we're going to have to get a little creative in how we get data. And so whether that's stories, whether that's getting other orgs to come in and give us data, maybe reaching out, and I have a few different contacts with the Council of State Governments. Maybe we could talk to them about coming in and doing a presentation on the remedies that they found, maybe with this group or potentially the data group, but having whoever's working on this particular project at the Council of State Governments come in and do a little presentation on this project that they're doing. And so if that's sounds interesting to either this group or Madam Chair Williamson, the data group, let me know how I can help.
No, and I think that that sounds great. And Mr. Vogel, I'll definitely, perhaps if I can just sort of leave that in your very capable hands of if we're struggling to hear back from DHS. You know, if that's another option, I think it sounds like we're potentially, I'll definitely open to that too.
Certainly, Madam Chair, and I'll coordinate with Vice Chair Evans to look into that. And just for the benefit of anyone watching this recording, Vice Chair Evans is referring to the National Inventory of Collateral Consequences of Conviction, which, to be honest, I didn't use that much in this preliminary research because there are a lot of collateral consequences for conviction. So it was kind of a cluttered database for my purposes. But it's a tool I will be using going forward, and you'll be able to find a copy posted to the task force website after this meeting. Sorry, a link to that website.
Perfect. So, you know, like I said, I don't know, is there, unless there's anything else that anybody, you know, really wants to discuss today. Ms. Evans, I see your hand is still raised. I'm not sure if it just, okay. I just wanted to make sure I'm not missing something. I guess unless there's something else, I think we at least have an idea. Our next meeting, I think, so it will be the 24th. Is that right?
Yes,
Well,
Madam Chair.
We're hoping to have DHS for that one, right?
Yeah.
And is it a holiday for them?
No.
No, I should apologize about all this holiday stuff. So Martin Luther King Jr. Day is a holiday. That's next Monday and doesn't affect this subcommittee. And then my confusion was about President's Day, which is February 21st, as I recall.
Okay.
Yeah.
Yep. So I think, you know, sort of just as we're all sort of thinking this through, our next meeting is scheduled for January 24th, and I'm looking at my calendar at 11 a.m. And I think our preliminary agenda topics, if we can hear from DHS, that would be, of course, super helpful. And, you know, I understand. And I think last time, Mr. Vogel, you had specifically talked about trying to reach out to even just their legal department so that we can really kind of get that big kind of overview. And then any sort of other further updates from you, Mr. Vogel, on your research. Is there anything else just that anybody wants to make sure? I think if we do have both of those, that will be definitely a good use of our time. But just in case, I guess, we cannot get DHS, does anybody else have anything they want to make sure maybe we can use our time for next, so that on the 24th?
Madam Chair, do you
Yes.
think it would be, so the 2008 recommendations from the last committee, I wonder if it would be beneficial for us to do a short presentation about what their recommendations for remedies were, so that we're not starting like.
I think that would be great. Thank you for that suggestion. Mr. Vogel, is that something that I know I'm adding to your plate? Is that something you think you'd have time? I mean, again, I'm not looking for a super in-depth and super long presentation, but is that something do you think you could do?
Madam Chair, yes. In large part because it's something that the disqualification subcommittee has already done something with, so I've got that. So I've done some work for that. And just for reference, I believe Vice Chair Evans is referring to DHS background studies, disqualifications, and set-asides, a report and recommendations of the 2007 Collateral Sanctions Committee. I'll send out a copy of that document to the members of the subcommittee, and a copy of that document should be posted to the task force website as well.
Yeah, and that would be great. And then, of course, if everybody, I understand you'll be doing a presentation, but I think it'd be helpful, of course, if all the other members can at least look through it, just so as we're getting the presentation, we can, again, just make good use of our time, and perhaps that'll help us as we're trying to move through all of this. All right. So perfect. I think we have at least a good idea and a good set for what we'll be wanting to do on the 24th. Is there any other business that anybody would like to address today while we're still here? Okay. So if there's no further business, then we can adjourn. Thank you, everybody. Stay
Thanks, everyone.
warm.